Welcome everybody. This is the first of the Stay Connected, Survive to Thrive series that we are putting out. And I'd like to welcome Brent Norling from Norling Law and Damien from Waterstone Insolvency, where today we are tackling the very juicy topics of protecting your business in this current crisis. And there are a whole bunch of things that we can talk about because, let's face it, there are a whole bunch of people that are hurting. So I'll just walk around the room. Brent Norling, welcome, mate. You want to introduce yourself and tell us a little bit about yourself and Norling Law?
All right, so thank you. Brent Norling from Norling Law. So Norling Law solves complex commercial disputes. We have a core focus on insolvency. So we don't do any of the general practice stuff at Norling Law. We really just focus on our niche. And right now we're having a lot of difficult conversations.
Mm-hmm.
Yeah.
Damien, welcome, mate. Waterstone Insolvency. Tell us a little bit yourself and Waterstone.
Well, we run a insolvency practice, so we primarily do exactly that. When a company goes into liquidation, we're the guys that do it. Probably about 20% of our work is restructuring businesses, so that's taking a good business with a bad or broken balance sheet and allowing the business to survive even though the limited liability entity that's running it doesn't. So that's and those are the conversations we were having about 3 weeks ago. Conversations we're having now with people is a little bit darker than that. So people are more thinking about, hey, do I just walk away? When's the right time to walk away? And yeah, so those are the conversations we're having with people now.
All right. So some of the things that I want to touch on over the next while we're having this conversation is dealing with the IRD. Reducing headcount and costs, which is a lot of people are looking at doing now. How's the right way and the wrong way about going about doing it? Payment holidays and plans with creditors. A very, very popular topic over the last week has been how to stop paying commercial leases or parts thereof, and what is a fair amount, and when to liquidate your business, and if you want to do that, what steps do you need to take. So let's start from the top down, and what suggestion have you got with everyone in and around IRD and dealing with IRD at the moment?
Well, let's start with the headline. There's conflicting messages. There's not conflicting messages. One of the things that directors need to be aware of is under the Tax Administration Act, if you collect PAYE and GST and you don't pay it to the commissioner, that is a crime under the Tax Administration Act. Not very many people are prosecuted for it, but it's still a crime. And some of the people that I've been talking with lately are increasingly concerned about that element of it. But at the same time, you've got Grant Robinson giving a really big steer. They haven't removed that criminal provision, but he's given a really big steer to the commissioner and her staff to be far more lenient with giving holidays, waiving interest and penalty charges. So I think from a practical, if not a legal perspective, people shouldn't fret too much about that. The idea is very slow in prosecuting people anyway, but that's one of the questions that I have been getting. People are concerned about that, and I can't tell them that law element has gone away. But from a practical perspective, look, the Inland Revenue Department, I think, reading between the lines and reading explicitly what's being said, I would never advise anybody, if you're sitting on cash, not to pay the IRD, but I think that a lot of people are doing exactly that. They're looking at their available cash resources, and if they have a GST and PAY obligation, they are choosing not to pay that. If you take Grant Robinson at his word, then normally one of the reasons why people pay PAY and GST on time is they want to avoid interest and penalties. So I think from that perspective, maybe people can sleep a little bit easier at night, that when we come out of this, if the business survives, then they're probably going to have a fairly easy conversation with the revenue about waiving some of those additional costs. They'll still be liable for the core costs, but there's a really good chance that the interest and penalties are going to be waived.
Great stuff. Now, can we just put a little disclaimer at the start of this, and I'm sure the two of you will be much better at wording it than me. This is not paid legal advice. This is opinion and this is insights. If you have got any problems within your business and these questions are being asked and these answers are helpful, do not take action without first seeking legal advice that you are paying for potentially. Just on the basis of the answers given on a webinar. There is a whole lot more to it that needs to be relating to your individual circumstance.
Yeah, totally agree. And I suppose to add to what Damien has said, I mean, most of the conversations that I'm having at the moment are not with business owners who have cash but are choosing not to pay. The conversations that I'm having are with people that have very limited cash resources right now, and they're having to choose who they're going to pay, and they've kind of got a list of priorities around that, how they want to use that money, and employees are fairly high on that list. So for those business owners, it's about communication, and I think communicating upfront with the revenue around your position and around what you want to do and what is sustainable is crucial. It's about making a proposal to the commissioner over what period of time you want to pay. So it is possible to spread those payments out, and it is possible to get the penalties written off when you make that proposal as well. So making those kinds of proposals are, I think, probably going to increase because people just are going to need to spread it out because their cash flow's dried up.
Mm-hmm. Should businesses front foot it with the IRD and call them and try and get a deal worked out and the proposal put together?
That's what I'm telling clients. So if you want to cut a deal, if you're going to default, and you need to be front footing that for sure, because having an upfront conversation and getting a deal is going to put you in a far better position than defaulting and asking for forgiveness in 6 months.
Brent, of your clients, any of those who have taken that advice, how are they finding actually getting in touch with the IRD? My dealings with them in the last couple of weeks have been very difficult to engage with them just on the workload.
Yeah, I agree. Getting in touch with the IRD is extremely difficult, but I still think making a proposal is the best strategy, even if the response is delayed, because again, it's better to ask for permission than forgiveness.
Well, and maybe if people have email addresses, they can make contact that way, because at least then you've got a paper trail that you may contact, even if the revenue is not in a position to respond straight away.
Yeah, exactly.
Absolutely. Reducing headcount and costs. This is something that so many businesses and small business owners, I know we fall foul of this time and time again, where we try and hold on too long, too hard, and it can end up crushing the entire business and making it not viable. So what is your advice around reducing costs and then reducing headcount? And is there any particular ways that you should structure the way that you look at that? Damien, maybe start with.
Yeah, well, I'll start with that. Probably the first thing to bear in mind is that people, if you have taken the government money, that's the $585 over 12 weeks, then I think you have a moral and possibly even a legal obligation. It's really unclear about how that works, to make sure that that money gets distributed to your staff. I think that's, I'm a little bit concerned that some business owners may be looking at that money as stuff that they could use for other things. So I think business owners need to be really wary about that. So if they've taken the money and then they reduce their headcount, then again, I think that's something that they absolutely need advice on. But the hard thing is the enormous uncertainty. I mean, this could be over in 2 months, we could be here in 3 years. And so I think makes perfect sense for company owners and company directors in this situation to bite that bullet. Just lay the staff off. If you don't think you're going to be back in 4 to 6 weeks, then I think it is the right decision to lay the staff off. maybe you want to pay them out some of the money from the government handout. But the thing is, you don't know what the future is going to look like. So for most businesses, it's staff and lease are the biggest costs. And I think if you are able to put your business into hibernation, then I think that's a really smart thing. That's absolutely what you should do. Also, because I think there's far more support potentially coming down the line from the state. So if you can, then I think people should.
Yeah, look, I agree, and I think for business owners who can't continue to trade through this period, which is there's a lot, I think that you've got a duty and an obligation to hibernate your business so you can survive, you can come out the other side, you can thrive, and you can be an employer again, because people are going to need jobs after lockdown is complete. And so, these hibernation strategies are going to be essential. And I think, to dive into how you have those conversations, there are a lot of business owners that are having upfront informal conversations with business owners, with their employees, to come on voluntary arrangements where maybe the hours are reduced, or maybe the money is reduced, and kind of the collective is taking a hit so they can come out the other side. So for businesses where they can partially run online and from their offices, that's a great way to handle it. And for others, they're going to need to run a formal redundancy process. And look, my view, and it's only my view, but I think that the normal redundancy rules can be relaxed during this period in terms of time frame. I mean, a redundancy process could take a month in normal circumstances to complete. I think it's entirely reasonable to take that time and reduce it down to just a few days or a week max. But it's really, really crucial that all the essential steps are complied with. So create a proposal, deliver the proposal, give your staff an opportunity to consider it, give their feedback, have a genuine consultation. Maybe staff can come up with an idea that might work, and then make a decision. And so those key elements need to be there, but I think it's entirely possible just to reduce that time frame down, because it's not a time for long drawn out legal processes.
Mm-hmm. Do you think that the 585 from the government for full-time workers for some businesses could end up being the poison chalice? They think, oh great, I'm going to get $7,000 per employee. That's going to tide me over. But in reality, when you've got a workforce that is $80,000, $100,000 a staff member, they're going backwards by $6,000 or $7,000 a month per employee that they're holding on to, where if they hibernate the business, they're actually protecting their war chest so that when the time is right, they can actually hire a lot of people back.
I don't know that there's anything that would stop you taking that government money and then paying the staff the $7,000. Again, you need to look into the legality of that. But I think if you did that and then laid the staff off, look, that's an area that I think you would need to take some pretty hard advice on. I mean, the government is paying that money up front in one big hit. So no, I don't know it's necessarily a poison chalice. I think it gives company owners and directors an option, and maybe it's an option that they shouldn't take. And you could be right, but no, I think I wouldn't call it a poison chalice. I think the thing to be very mindful of, if you take the government money and then you lay them off, one of the criteria was that you need to make best endeavours to keep the staff on. I think it was 80% of their formal wages. And so if at the time you took the government money, it was your intention to do that, and then you find out down the track that you can't, you come under the best endeavour rules, I think you would get into trouble if you took the government money and then closed the business and started the process the next day. That's where you might get yourself into trouble.
My understanding from what I've read on that is if you do let them go before the 12 weeks is up, then there is an obligation that you pass the remainder of that money on to them to tide them over.
Yeah, and I mean, and my conversations with business owners, that's exactly what they're doing. I mean, look, the reality is, even if you make the staff redundant, chances are you're going to be paying them more than the $7,000 from the time you receive the government money until the time that their last paycheck stops. It's going to be more than $7,000. And remember, if you make somebody redundant, you've got to cash out the holiday pay and other leave obligations as well. So there's not going to be many situations, I think, where you're going to make somebody redundant and not end up with a $7,000 liability.
Yeah. Brent,
No,
you're about to say something.
Covered it off. It's fine.
Excellent. Payment holidays and plans with creditors. Brent, you've been touching on this quite a bit in your incredibly rampant social media barrage this week. You're a very popular man.
Thank you. Too kind. So look, the theme of my messaging has really come down to communication, and the reason I've chosen to focus so hard on upfront communication is because us Kiwis are just so bad at putting our head in the sand and hoping that it'll go away. And hope is a terrible strategy. So if you have creditors and you're struggling to pay them, it's really important that you don't wait for them to be chasing you and for that frustration to just escalate. I think front foot it, get on the phone, talk through your situation. The reality is we are in this together, and we are going to need to share the burdens. And the reality is a lot of businesses are in similar position as you. And so have a conversation, say, look, I just don't have the cash flow. It's been turned off overnight. And have a conversation about what you can do. So I need a holiday till that my business is reopen, or I can pay you X amount per month because I have some cash flow, but it's not like it was before. Whatever the arrangement, there needs to be some one-on-one conversations around that. And if you are the creditor, it's the same. Upfront conversations. And you're going to need to be understanding of businesses that can't pay, because what we know is that there are only two types of debtors: people who can't pay and people who won't pay. And so it's really important that if you're in the position of a creditor, you ascertain which category is my debtor in. Are they in a can't or won't category? If they are in a won't, because there are people that are just contracting and holding on to their money, then it's time to drop a hammer. And I think just because we're in lockdown doesn't mean you can't drop a hammer. And so if they won't pay,
the favourite Norling law quote, "Drop the hammer." Do you want to just expand on that for the sake of the people that don't know what you're talking about?
Well, look, the hammer depends on the circumstances. But if it's a company that owes you money, like I'm hearing some stories from people that I'm talking to who are small businesses that are owed money from large corporations that are just stopped paying. Issue a statutory demand on that company. I'm sure they will pay if they're in the category of won't. And so, stat demands, they can still at this stage they can still go out.
Are you should just clarify that, Brent. So we're both aware of at least one process server who was vigorously out there serving documents. Is that an essential service? Can you actually do that? And more importantly, I know the courts haven't given any formal guidance, or the Parliament hasn't given any formal guidance on the 15 working days and other statutory timeframes. So what's your view of how that currently works and how that's likely to work once the lockdown ends?
Yeah. So look, I'll just take a couple of steps back for the viewers. So statutory demand in the usual course needs to be served on the registered address of the company or on the director personally, right? And so in lockdown, it's going to be really difficult for that to come to the attention of the director if the office is served. And so those usual ways of serving, I'm probably reluctant to use. And so I know there is a document server out there serving documents, and he's taken the view he's an essential service. I'm yet to confirm my view. I think it's arguable that they are as a business that supports the Ministry of Justice. But with statutory demands, they can be served by alternate methods. And I know some of our judges in Auckland disagreed with this decision when it came out, but there was a Christchurch High Court judge that said service by email is effective. And this was prior to COVID-19. So as long as you could show the email was of a senior member of that business and they were using it. So if you can show they've replied to something recently, then he was prepared to accept service by email. So I, for one, if I can show there's an active email, I'll be serving stat demands by email.
So if you were using something along the lines of HubSpot, where you can track open rates, and things like that, and you can show that this email has been sent to the director and the director has opened that email, then it may be deemed as served. Possibly.
Well, I mean, I think it's very arguable that it is. And, you know, for people who won't pay, my advice is is business as usual. For people that can't pay, it's, you know, communicate and come to an arrangement you both can live with, even if it's only for stage 4.
Well, because we just on that, we had a liquidation application hearing on Friday for one of our other businesses. We're attempting to put a debtor into liquidation, and the normal liquidation list for Friday has been postponed. It sounds like it's still going to go ahead, but at the moment, the liquidation applications seem to be caught up in this whole process.
Yeah. So look, the court is refining its processes, and it is accepting documents by email. At this stage, it can't accept payment online because they still require checkbooks. So until they get their system sorted, filing fees are free, and you can email those in. So you know, we will continue where necessary to file documents. You're right; they have been pushed out, but they are going to continue. And I think, you know, the whole ministry is just getting to grips with lockdown, health and safety, all of it. But also, their systems are very, very dated. And you know, there's been talks for the whole time I've been a lawyer, 10 years, of this going online, and it hasn't happened yet. So I think this will be the catalyst that pushes us into an online filing and payment system, which is, you know, it's a silver lining. I'm really looking forward to this.
It's a very small silver lining on a very dark cloud. I guess we take.
This is true.
So speaking of dark clouds that have silver linings, let's maybe, Damien, do you want to just take us through when people should look at liquidating their businesses and the steps that they need to take? Because for many of us, it's the last thing we ever think we would want to do, and no matter how sensible the decision may be at the time.
So I guess businesses need to decide which category they're in. Some business owners are coming to the realization that their business is not going to survive. And well, actually, let me take a step back. So you've got two things. You've got the business and you've got the limited liability company that runs the business. And those are not necessarily the same things. So you may have a cafe. The cafe's got a lease and other obligations. You may find that the obligations sitting on that cafe are potentially going to accumulate during this crisis. The business is potentially going to come out the other side. But the question that business owners need to make is, do they want to run that new business inside the old limited liability entity? So you've got to remember, so you've got the business on one hand, but the company on the other. And there are, if you think, right, well, I want to continue with my business, but I don't want to use the old company because it's run up all of these obligations during the COVID-19 mess, the critical thing is going to be whether or not your landlord will allow you to do that, because if you liquidate the old company, then it will be at the landlord's discretion as to whether or not they will give you a new lease and a new entity going forward. So dialogue with your landlords during this period is really critical. But to answer that question, so again, is your business one that can go into hibernation and come out the other side? Now, you may not know the answer to that question right now. You may think, so if this is going to be a V-shaped recovery, we're down for 4 weeks, another 3.5 to go, we come out the other side, and you think your business might be good to go, then under no circumstances should you even contemplate liquidating the business right now, because you're going to want to know down the line whether the business can come back. So for those owners, and there is no real downside, in my view, to stalling that decision. Absolutely none. You're not, in my view, you're not breaching any of your duties as a director if you continue to hold this to roll the business over in hibernation. But then there's another type of business owner, and these are the guys that I was talking to 2 to 3 weeks ago. They're kind of going I find at the moment. People whose businesses were already a little bit marginal. So if you had a business that was, you know, you had a small profit, but it was pretty shaky, and this event has pushed it hard into the red, and you don't have confidence that it's ever going to come back, then yeah, I don't know that for those businesses there's much value in holding on. But in terms of the process, a couple of things you need to do. The first thing, before you approach an insolvency practitioner, you've got to get your head around what the liabilities are going to be once you liquidate. And for most company directors, that's your personal guarantee obligations. So who do you have personal guarantees? Do you have a personal guarantee with the landlord? Do you have a personal guarantee with key suppliers, you know, placemakers, the coffee distributor, whoever it is? So you need to get your head around that. And maybe if you're looking and you have a big ugly lease obligation, the one thing you may want to consider is there a means by which I can terminate this lease prior to going into liquidation? Is there something you can do to mitigate your personal guarantee obligation? But once you got your head around that, look, putting a business into liquidation even during lockdown is really easy. You just need to get in touch with me or somebody like me. We can do the paperwork over email. There are anti-money laundering obligations. It might get a bit tricky, but again, in most cases, we can resolve that remotely. Practically speaking, I find this hard to believe, but insolvency has not been deemed an essential service by the state, which is deeply personally hurtful. But what it does mean is that if you put a business into liquidation during lockdown, it means that the insolvency practitioner can't physically go and secure the assets. So that's something to bear in mind. But certainly we can freeze bank accounts. We have situations where companies are having money taken out of their account by direct debit. That can be a very difficult thing to stop and control, and so liquidation is a very effective means of stopping that. It gets you around the whole redundancy process and all those sorts of things. But the thing to do in the first instance is, once you get to that point, just call an insolvency practitioner. Most of the insolvency industry is still active and working from home. So if you speak to one of us, yeah, we should be able to guide you through the process.
Yeah, I'm going to take a different view to Damien, which often I do. Sorry, Damien. Look, my view is not all insolvency practitioners are as ethical as my friend Damien. So calling an insolvency practitioner often is a poor starting point, and the reason is, you know, you go to a dentist, what do you end up getting recommended? A root canal. You go to a liquidator, you're going to get a recommendation for a liquidation. And, you know, apart from my friend Damien, who always does the right thing. And so, you know, my advice is actually reach out to someone you trust, ideally with some insolvency experience. But I mean, a starting point could be your accountant, and they might be able to nudge you in the right direction. Otherwise, you know, we offer a free 30-minute legal consultation. but seriously, insolvency can be a very complex. It can be a very complex minefield, and Damien quite rightly has pointed out that the difference between a company and the business, and the ability to save the business through a Phoenix hive down, and the starting point for establishing a company with a similar name is that it's prohibited. And it is an offence if you incorporate a company with a similar name to a failed company. But like all good legislation, there are a lot of exceptions, and so you can do it, and there is a way to do it, but you need to be talking with someone that actually has navigated that multiple times before, because it is a minefield. The outcome can be imprisonment, it can be fined, and it can be being banned as a director for quite a number of years as well. So, oh. Dunno. So yeah, I mean, I think it's good to get some advice, and look at strategies to hibernate first. Are there ways to hibernate a business to avoid liquidation? And the conversations that I've been having around liquidation over the last week and a half have been with people who were already struggling. They already had issues, and they're the people that are going to fail first. And what we know is, often it's like dominoes, and if one big domino falls, many can follow. So, think like Mainzeal and Eberts and those kinds of companies that have failed in the past, 6, 12, 18 months later, the other dominoes fall. So it might take a while for some of these companies actually to get to that point.
But also, Brent, I think it's important we should point out that there are a couple of mechanisms. So you alluded to the Phoenix company restructuring. So that's where a company, the business is good, but the company is broken. And so in that situation, you can liquidate the company, and then the company director can buy the assets off the liquidator. You've also got voluntary administration, which I know that neither you or I are particularly a fan of, but it might be quite useful in a situation like this, where you can hand the company over to an insolvency practitioner with an eye to potentially doing a deal down the line, and that's a formal deal with your creditors. But then also you've got what's known as the Part 14 compromise in the Companies Act, and that's where, with 75% of your creditors agreeing, you can say, listen, I owe my creditors $1 million. I can't pay you. I can pay 30% of that over 2 years, and if 75% of them agree, then you can. That's binding on all of them. So there are, for those situations where, as I was saying before, you've got a business that's good, but a company balance sheet that's broken as a result of this. There are parliaments. There are parliamentary and statutory options that may well be useful, and I think we're going to see a lot of that sort of activity happening in the next couple of years.
So I hope you're not currently taking control of the assets of Tegel at the moment, Damien.
I would appear to have one rogue chicken that has come back into the premises, but yes.
I think they'll be fine at the moment. Anyway, now the biggest talking point, and look, if anyone's got any questions that they want answered, not legal advice, but if they've got any questions that they want answered for some insights and opinion, feel free to sing up. Now, yeah, the real hot topic, and I think you're even on TV on Friday morning, Brendan, around this, was in and around commercial leases. Now, the two of you had an amazing, robust little session on this last week, where you're talking around how a clause in the agreement that could potentially mean that you don't have to pay your lease in the time of an emergency or a shutdown. Can you expand on that?
Well, Brent, you should take this one.
Okay. So yeah, and what we've chosen to focus on is the the latest Auckland District Law Society standard deed of lease, because that's the most common one in the marketplace, and also it does have a clause that specifically refers to no access in the case of an emergency. So essentially, that deed allows tenants who are unable to gain access due to an emergency, of which this has got to be one of them, to suspend to pay a fair amount during that no access period. And look, that's been the great debate that's kind of consumed my week last week around what is a fair amount to pay. And I think a lot of landlords are taking the view 50% sounds fair, and a lot of them are also saying no, contractually you're bound to pay 100%. And tenants who can't gain access are saying, well, I've got zero access, I want zero rent. And there are landlords that are cutting those deals as well. And I'm aware of quite a few cases where that's happened, and it has been for just a stage 4 at this stage. So we'll review it again in 4 weeks, because the reality is we don't actually know how long we're actually going to be in lockup for. But I think everyone's guess is it's going to be more than 4 weeks. But that's the landscape we're dealing with currently. And I mean, there are other contracts that are used in the marketplace, and a lot of the larger landlords are they have their own bespoke agreements, which are just completely silent on this issue. And for those people, you got to be careful, but there is a doctrine of frustration, and that allows the parties to the contract to cancel the contract if it's been frustrated due to neither default, not the default of either party. So, there are people who now want to get out of their leases. They understand that they can't access them, but even when they can, they don't need that space anymore, because they're not going to be the same size as they were when they came into this. And so there is that doctrine that's available for some people to get out of their leases. And it's, like I said, you've got to be careful because it can trigger some unintended effects. If you wanted to do was suspend rent, and then you ended up with a cancelled contract. So there are some minefields in there. So yeah, those are the.
So Brent,
question.
Just diving in on that for a second. So if you have a lease and it doesn't have the specific clause that the ADLS one does have, so you're saying that the doctrine of frustration, so this is a common law doctrine that can be applied to that contract, even though it's not specifically allowed for in the contract.
Yes, correct.
And would that so let's say that a business owner in this situation, looking at that situation, says, right, would they be potentially able to cancel the entire agreement, including any personal guarantees that go along with that? Are there potentially directors in that situation? Because I just know that some directors are very mindful of their personal guarantees on their leases. Is there potentially an opportunity there?
Yeah, there is potentially an opportunity, and it is arguable. But what I would say is a couple of things. The doctrine of frustration will apply to commercial leases, but it also will apply to all other contracts as well. So if there are contractual commitments that businesses have, and they've now been frustrated, the doctrine of frustration may assist. The other thing I've got to mention is we are in unprecedented times, and it's really easy for me to say, yep, this is an argument. That is just my view based on what I know, but I'm unable to actually go back to the judicial history and say, here's a case with similar facts where this was the outcome. And so the first person to run this argument, and if it goes to court, is going to be interpreting that for everyone that follows, really.
So would the closest be Christchurch after the earthquakes?
Yep. There was, the problem with Christchurch, there were a lot of overhaul of contracts after Christchurch, and people did allocate the risk, and just like the commercial lease I'm talking about, that was as a result of the Christchurch earthquakes. The Auckland District Law Society decided we're going to shift that risk and deal with it explicitly.
Cool. Would that be passed on to people that are subtenants?
Yeah, you got to think about it in a chain. So subtenant's relationship is with the tenant or the head tenant, and so that's the relationship between those two.
And they will all have their own agreements as well. But does the primary lease agreement take precedence, or is it just whatever the individual agreement is down the chain?
Yeah,
there are a lot of people with subleases, right?
That's right. So it really depends how they've structured their sublease. So if the head tenant has entered into a separate lease agreement with the subtenant, then it's going to be that lease agreement that you need to take into account, and the actual head lease you don't need to consider at all.
Mm-hmm.
But then some will incorporate some other obligations from the head deed. So it just depends.
Yep. And would the frustration piece come into play with, say, and I'm sure there would be a load of businesses right now who had signed leases, had signed agreements, due to move into the premises over this period, but have not either been able to vacate their existing premise and get into their new.
Yeah, look, and the same principles apply. I'm actually in that situation myself, where I signed a new lease. I was due to move in on the 27th of April. There's a whole bunch of fit out work that needs to happen before I can even get to that point. But the reality is, I don't want to cancel that lease. I just want to push the commencement date down the track. And so my focus has been, can we change this commencement date rather than can we terminate this? But yeah, these are ways that business owners can deal with situations like that as well.
So I got a question here looking for a review on essential services. Somebody's got an essential service business who is choosing to not work from the office as per advice. Because they are choosing not to work from the office, would that enable them to enact that?
Yeah, this is an interesting one, and it's a great question. I think it's going to be much harder for someone who is an essential service to say that the government has restricted their access to the building, which would then trigger this clause. But there is some provision in there around, if I recall correctly, to fully conduct their business. So if they didn't have access to fully conduct their business, so there's possibly some arguments in there, but it is going to be much harder for them.
Yeah. So if every staff member had to be 2 meters apart from each other, and then it just wasn't feasible for them to conduct their business as per normal.
Yeah.
Okay. Hope that helps, Simon. And that's what Simon thought. Perfect. Excellent.
I guess one of the other things that might come up is, depending on how this whole thing pans out, there may well be situations where you currently have a business, set up for 15 or 20 staff. As a result of this, you're going to need less staff. And my suspicion is that leases are going to get cheaper as there's going to be a wave of insolvencies and restructuring. So that may well be something that people need to consider, and particularly I mean, I know, Brent, you're going through a process at the moment where you're moving from a smaller office to a larger one. But people who are currently in larger offices may well want to sit there and think, okay, if you're looking at a lease renewal now, maybe you want to actually go on a month by month, because the uncertainty of where the market is going to go is going to be really unclear. And so there are potentially some opportunities. But I guess the flip side of this coin is we shouldn't leave this out. There are going to be landlords as well who are really going to be stuck here. So we have a view in our mind of landlords as being, super wealthy individuals without balance sheets, and that's simply not true. You're going to have a lot of landlords that are caught in this situation, and they've got tenants that are not paying, and then they've got the back-to-back situation where, well, the bank isn't necessarily going to cut them any slack, and so they've got the potential that you've got landlords who are unable to make their mortgage obligations as a consequence of this. And even though there might be an explicit or implicit frustration clause in a tenant's agreement, there's not going to be that sort of flexibility with banks. And so, I mean, Brent, do you have or Glenn, any view about how a landlord caught in that situation should approach it?
Well, I was going to say, this is flowing upstream, right? So tenants are demanding zero rent. Landlords are very much the piggy in the middle here, and banks are probably going to need to come to the party on this to save their portfolio of landlord clients, and it may be that some holidays for commercial landlords are going to be necessary as well.
Because I know there was some conversation about domestic mortgages being potentially put into abeyance for the duration of this period. Now, the reading of the fine print on that, I don't think that's been formally put into place yet. But this is not a mortgage holiday. This is simply a pause. And so the obligations are going to accrue. And so you may end up paying more out the other side if you're delaying paying the interest. So I guess, and I haven't seen anything with respect to commercial premises yet, but I think we can expect to see something along those lines. So I think if you have commercial property and you're in that situation, having a conversation with the bank is probably the smart thing to do. But I suspect that that you need to bear in mind, of course, that when you got the initial loan application, you would have given to the bank your balance sheet and financial history, and so that may potentially come back to haunt some people, because the bank's going to
as a small-time landlord myself, I can tell you the words from the bank so far is deferment, which means that all that interest is accruing and you're going to pay for it anyway. And in fact, in the long term, it's going to cost more. So we're of the view that if we've got a war chest, we're going to use it because they don't want to end up paying more in the end. And so it's to go to interest only. We're going to actually cover this in a lot more detail tomorrow with Campbell Hasty. When we're talking around residential sales, tomorrow, residential sales, the view on how the banks are taking things, and also the rental market, what's happening with landlords and tenants on the residential side of it too. So really interesting times. And one thing I do know, there are going to be people that are going to lose entire businesses and fortunes, and the reality on the flip side of that is there are going to be people that are going to take advantage of it and make a shit ton of money out of this as well, because they are cashed up and ready to take advantage of people that aren't in a good situation. And that's business, unfortunately. Right. So I really appreciate you guys coming on, and look, keep on the great work on social media. Keep on sharing that information amazingly well. If anybody wants to get hold of either of you, Brent, do you want to give you the website first, and then Damien, you can?
Yeah, sure. So look, couple of things. If you're a business owner and you want to look at the hibernation game plan, I've got the book on the website. So head across to www.norlinglaw.co.nz, and likewise there's a calendar link in there to book directly with me for a free 30-minute legal consult if you need one.
Damien.
Yep. So if you just go to our website, www.waterstone.co.nz, and again, you can book a consultation or just call us on our number 0800 closed, which is still active, and people will answer it. We've also got some stuff out there, particularly on directors' risks and obligations, and another book called Insolvency 101 that I think a lot of people are going to find quite helpful in the current environment, because there is a lot of company directors who have never had to consider these issues before are now suddenly having to consider them. So, yeah.
All right, really appreciate it, both of you. The reason I got you both on is because if there are any two of the good guys that are out there in these industries, you're the two that I trust implicitly in sharing the right information, not just the information that's going to benefit you. So thank you very much, guys.
If Brent and I are the good guys, we are in serious trouble.
No problem. Anyway, have a great one. And Dean, who was asking the question, how do we get an invite for tomorrow with Campbell Hasty? If you go back to the booking page, which is on the Konnector website, which is konnector.co.nz, that's Konnector with a K, / stay-connected. I'll pop it in the link and I'll send it out to everyone. If you go back to our website, then there's links to register for every single one of this week's webinars with everyone that's on there. So, hey, thanks, guys. Have a great one, and we will catch you on the rebound. Stay connected.
Cheers.